I got into my approach to planning is from where I come from. I'm mostly an environmental lawyer. That's my approach to these issues. I kind of stumbled along the way on community development, working with groups, and eventually after Hurricane Maria, like a lot of us, well, I became a disaster attorney because that's what we all needed to do. I know this is a story familiar to at least one of you, right, Susana? This is just kind of what happened to all of us. So we started working from Ayuda Legal on disaster recovery and disaster response, trying to make sure that the most amount of people got aid to get back to the position they were before the hurricane, or if possible, even better position, having safer housing, better conditions to face the new disasters that are sadly going to be, or events that are sadly going to be part of our life since as climate change increases, as sadly as our infrastructure keeps deteriorating and the recovery doesn't seem to be happening fast enough. We've been ongoing disasters for the last at least 8 years since Maria. Then we got the earthquake in 2020. We got a strong earthquake for the first time in 100 years, early in 2020. COVID, then Hurricane Fiona in 2022. So we've been getting disaster on top of disaster while still waiting for recovery for a major catastrophe that was Hurricane Maria. And one of the most important pieces for people to get aid at this point was lack of formal ownership from their homes. Which sadly also is not exclusive to Puerto Rico. Just this week, I was meeting, we were doing a workshop for our partners in North Carolina dealing with the aftermath of Storm Helene, and they're in the exact same position, sadly. So this is not unique to us, but I think was very accentuated in Puerto Rico because there are large numbers of people that do not have formal title in our country. I tried to create a little bit of a presentation for you guys, smoothly, so I don't start talking about different, and lose my time. It's formatted as a little bit of a timeline, so we can get how things changed or did not change along the way. This is where we were right before Maria hit. Around 44% of the people in Puerto Rico live in poverty. Average income was around $20,000 per household. We had more people living under poverty than the poorest state, twice as many as the poorest state that's Alabama, if I'm not mistaken. We have estimates, but not really good data that seem to suggest that about half of the homes in Puerto Rico are in formal construction. And a similar number may be, or probably a little bit less, you see a lot of different numbers on this, didn't have a formal title to their homes. There's, I believe, a few reasons why that happens. For one, there's no obligation under Puerto Rico law to have a title to your home. No one has to inscribe their rights at the register of the property. No one really has to do a written contract to transfer property on the Puerto Rico law, especially before the 2020 Civil Code. A verbal contract was valid, so you could transfer property just in a verbal deal. And there's a large number of people that either rescue land, which is what we call when people build their homes on land that doesn't really belong to them, partially because a large number of poor people, historic trends that started in the middle of the 20th century when people basically abandoned the countryside and came to San Juan and the major cities for works in offices and work in industry. And finally, the reality that legal processes to get a formal title are just hard, burdensome, in many cases, very expensive. It might not have, if you don't feel like you're at risk of losing your home, the idea of going to a legal process where you need to hire a lawyer to divide the heirship, what you got from your parents, it might not be reasonable for you to do. In some cases, it might be very hard to do, even if you get a free legal support. I'm thinking the process just to declare someone an heir when there's not a will, it can be it's a fairly simple process if you know every heir and every heir is alive. But when we're talking about that land that belonged to your grandparents, and you know there's heirs in that line that live in the United States, and that you know everyone calls him Pancho, but you don't really know what Pancho names is, or if he's still alive, or if he had kids, it's very hard to track that down and clear that title so you can get a formal title over that land. On the Puerto Rico law, however, that doesn't mean you don't have a right over that land, or you are not the rightful owner of that land. So when Maria hit, people were living on their homes like they always did, but maybe without any documentation to prove that they were the owners of their own homes. Some 725,000 homes were affected by Hurricane Maria. That's about 60% of all the homes in Puerto Rico. This is a study that Deepak Lambat made. FEMA received over 1 million applications for aid. Sorry. But at the end of the day, just those are current number, FEMA aid only got to 475,000 people. And we estimate, I think these are numbers for the National Low Income Housing Coalition, over 70,000 applications were denied because people did not have a lack of title, which tells me that a lot of people requested aid, and the only reason they did not get the aid they needed and they deserved was because they could not prove to FEMA. I'm so sorry. They could not prove to FEMA that they were the rightful owners on their home. And this is doubly problematic because FEMA doesn't require people to have a title to get aid. FEMA is a federal agency. Federal government doesn't get to decide who owns land in a territory or in a state. That's the exclusive domain of the local government. So what they usually do is apply their own rule, their own definition of who is an owner occupant of a home, which includes people who have a formal title to their home, but also people that don't have a title and don't pay rent, but pay property taxes, or are the ones that are responsible for the maintenance of a home, right? If something gets damaged, the person that lives there is the one who fixes it. And it's not because they have an agreement with a landlord, they're considered the owner of a home. If you have a lifetime occupancy right, you are the owner of a home according to FEMA. And yet, by 2017, they were asking people to prove that they were the formal owner of the home to receive aid. There's many reasons why this could happen. Partially, this is the post-Katrina effect of getting tougher regulation to, in theory, stop abuse and corruption and people getting aid they don't deserve, or people stealing aid, which just usually translate, instead of getting the contractors that are the ones that usually are convicted for stealing FEMA money, they put more pressure on the people that need help instead of making it easier for them to get, even they have no reason to. By 2018, a broad coalition of organizations that were on the field working on FEMA applications and seeing the FEMA denials, worried that FEMA is really not applying its own rules. We got FEMA to at least accept what we call an ownership declarative statement. It's a simple document where the person can just check what their situation is, explain what the situation is, basically say, I don't have a title, but I'm the owner of this home because I inherited from my grandparents, or because I've been living here for 40 years and under Puerto Rico law, that makes me the owner of this land. Funny things happen here. FEMA did look at the document. FEMA did say it would be good enough for people to use it and prove to FEMA that they were the owners. And they posted on their website press release saying that this happened, that Ayuda Legal, Servicios Legales, and a few other organizations had created this document that would be available to people applying for assistance or presenting appeals for their denial, but refused to send it to people that were denied their housing aid because they did not prove that they were the owner. Meaning that a lot of people that probably had a right to aid, but couldn't prove it, didn't know this was an alternative for them to present an appeal or to present in the application process so they could get the aid they had a right to it. By 2021, FEMA announced that it had changed the documents that would allow people to use to prove ownership, that it would make more flexible rules, so more people could get aid. It also published a new suggested language of what that document needs to say. It's not a template, it's not a model, but the language is there in the FEMA website that what the document needs to prove or needs to say, so FEMA can take it as ownership or occupancy proof. This applies to all owners, to all disasters after 2021. And in 2024, they announced new rules that make this process, at least in theory, more flexible, and hopefully will mean that more people will get aid to fix their homes after a disaster. And this is the direct result of the advocacy we did in Puerto Rico to make sure that people have more options to prove that they own their homes than providing a mortgage document or providing a deed of sale to FEMA. However, FEMA is not the end of the sorry. FEMA is not the end of the legal aid or the federal assistance for disasters after a disaster. FEMA is basically the ambulance, the immediate response. Long-term support is supposed to be done through CDBG or Community Development Block Grant funding, which is supposed to help people that did not get sufficient aid or still had unmet needs after FEMA can get into a safer place to have a safer home after a disaster. Much to our surprise, in 2018, when the funding is announced and is allocated, it still included tighter requirements similar to what FEMA was requesting the year before, and that we have fought so hard to get FEMA to change. That first allocation of CDBG funding was early February 2018. It was over $1 billion. It's now over $10 billion just on disaster recovery funding. The first action plan created, I think, the symbol of this process, or the main program for the CDBG funding when it comes to housing, which is the Repair, Reconstruction, and Relocation Program. And it also included a title clearance program. The title clearance program was never on the draft action plans. There was an entire, Lucina might remember this, we were all trying to comment on 3 different drafts of the action plan. There were public hearings around the island. None of them ever mentioned anything about title. But once the final action plan was approved, there was a title clearance plan program. And I think the reaction for all of us was, what is this for? A lot of people, would be interested in getting a form of title to their homes, legalizing their relationship with the land for sure. But what are we talking about title in the context of disaster recovery? Our position was and still is, title should not be the determining factor in if someone gets to live on a safe home or not. So including it in disaster assistance was very problematic to us, especially once we see the guidelines of how the R3 program is going to apply these regulations and use this title clearance program. Those were published in May 2019. By the summer, right during the protest against Ricky Rosselló, who ended up being ousted as our governor that summer, they published the regulation. They start taking applications for the R3 program. About 27,000 applications are received between August 2019 and January 2020. The program closed for applications in January 2020, still closed. They're still trying to support the 27 people that applied. They have rebuilt about 3,000 homes, repaired a bit more than 3,000, and 3,000 more have vouchers. to get a new home and relocate from their homes, because according to the R3 programs, their homes cannot be rebuilt. Which means that's 9,000 to my count. Let's say 10 being very generous, 17,000 people are still waiting for aid or waiting to be denied aid. Those guidelines had very explicit rules about ownership and very strict rules about ownership. And the main reason it was that definitely applies to you guys as planners, is because the planning regulation says that anyone that needs a construction permit or a demolition permit needs to be the owner of the home. So what do? They get that regulation from the Reglamento Conjunto, which is the main planning regulation in Puerto Rico. And they say, if you want aid, you need to provide us with a deed to your home, a certification of the Puerto Rico Property Register, or a declaration of ownership. All of the things that we already know that about 50% of the people on the island, probably those who need the most help, cannot do. They also said you can provide us, if you cannot do that, you can provide us with an ownership affidavit when you say that you are the owner but don't have the documentation, and you will be sent or will be referred to the title clearance program. The title clearance program will help you formalize your tenure. You will get, they will help you get a title, and once you get the title, you get the aid. After you clear your title, you will get aid to repair your home. According to that first guideline, you had about 6 months to do that, to go to the title clearance program, provide them all the documentation, and they will give you back a clear title in 6 months. As an attorney that worked on housing for the last 15 years, I can tell you I've seen processes for title clearance that take 10 years. I don't think I've ever seen one that takes 6 months, or very few ones that take less than 6 months, but those were the rules. If you did not get your title in 6 months, R3 program was under no obligation to save the funds they had allocated for your home. To keep them, they could go to somebody else. Eventually, however, they realized the same thing I just told us. Getting a clear title is a lot harder than it looks. It takes a lot longer than 6 months. By 2019, they start kind of backtracking on those first regulations, but they still insisted that you had to go through the title. So I'm sorry, I said 2019. After 2019, they realized the same problem I was telling you about, and they started backtracking on those first regulations. By 2022, they recognized that what you had to prove to get aid is a proprietary interest. You don't have to be an owner of the home. This is language that we suggested, language that we like, because it's a different legal standard than ownership. You can have a right to something without being the owner. If you inherited your property and you have siblings, you probably have a right over the property. You're not the owner, even if you live there your entire life, which is something that is very hard sometimes for people to understand, that you can live in a house since the day you were born, and you will still not be considered legally the owner. You have a right over it, but you're not the owner. They also got the OPE, which is the planning office or this department's office, to accept and create changes to their own regulations, to accept that ownership certification as proof of ownership. Therefore, after 2022, Vivienda could finally go to OPE, request permits for construction and demolition using just the word, basically, of the person that was going to be getting the aid, and not require further legal documentation that they could probably not provide to get permits and start construction. Okay. The title clearance program's guidelines, however, remained a little more fuzzy. We've had 16 versions. Notice, sorry, if for 2022, we were already on version 11 of the R3 program guidelines. It took them 10 amendments to realize that what they had created originally was not going to work. The title clearance program guidelines were changed a lot less. I'm sorry. We're on the 5th version of those guidelines. Wasn't until the 3rd one that they started to change the language of who can get aid, who can get assistance. By 2022, so that's 4 years after we got CDBG funding, finally, the guidelines for the title clearance program said that the applicants that were referred to a title clearance program did not have to wait for the title clearance program to get them a title, but they did have a requirement to cooperate, to participate with the program until they got a clear title, or until they got a notice from the title clearance programs telling them that their applications had been closed because a clear title cannot be obtained. There, those other inheritors are nowhere around. You don't have enough legal proof to show that you've been living in a lot for over 30 years. Those processes cannot be finished. So you will get a notification that you cannot get a clear title. And your case for R3 was now separate. You can still get aid from R3, even if you did not get a clear title. I will note, I did not include it, this requirement to cooperate with the TC program comes with a warning that if someone going through this process is not cooperative enough, it doesn't provide truthful information, Vivienda will ask for every penny they invest in trying to get them a clear title, and they will get it back from the person that is supposed to get aid. So someone that maybe got tired on the process and didn't answer could see themselves in risk of a recoupment process if they were referred to the title clearance program and couldn't get a title cleared. Finally, in 2024, it says in black and white that if you do not get a clear title, you will not be considered eligible for assistance from the program that referred you to the title clearance program. Where are we now when it comes to the title issue? Well, earthquakes survivors, the ones that, the 2020 earthquake survivors got $221 million for assistance. Those people are getting preferred to the R3 program for repair and reconstruction. By the way, as of the end of September, not a single house has been repaired, not a single house has been rebuilt. They're still waiting, but they are supposed to be part of the R3 program. And there's still a doubt what's going to happen with the title issue. I assume under the rules, we're of the understanding that they will not be required to provide a clear title because the same rules apply. But it's unclear if they will be referred to a title clearance program because of that. Those guidelines actually show the Vivienda is still evaluating the budget to see if they can refer earthquake survivors to the title clearance program. The title clearance program also got a new expansion, gave them a bit more, a little bit more of responsibility or things they can handle during the process, because it turns out even if you are the owner of your land or your home, you can still need more legal assistance regarding to the title to get aid the way Vivienda designed it. I'll give you one example because this is the most we've seen. A lot of people that are farmers live on their farmland, right? So if your home is in your farm, you might have 40 acres of farm. That's your livelihood depends on that. That's your work. And Vivienda says you cannot stay there. You need to relocate. Vivienda, during the process of relocation, technically will have to get your land, give you a voucher for aid, and you go get a new home. That voucher is max $200,000. So you would technically be giving Vivienda 40 acres of prime farmland for $200,000. That doesn't make any sense. And to Vivienda's credit, they realized that's not what the process was meant to be, but also they had no way out of it. So they had to change the title clearance program so they could allow those lawyers working through the title clearance program to be able to do segregations, to do other type of title issues, to separate that house from the farm, so Vivienda could take the house and the farmer could take their land. But until this year, they were not allowed to do that, which meant that there's people since 2019 waiting for aid because there was no one at Vivienda that had the authority to ask for a segregation or a notification of that plot. That's new. And I'm sure exceptions like that happen along the way a lot. And they notice that what they're calling title issues are probably gonna be well, as different in every one of those 27,000 cases they got, they're gonna have different title issues in all of them. Because that's just, the problems of getting a CBDG funding that is meant under or is done under federal regulations that reflects the reality of the 50 states and their Anglo-Saxon system of ownership, and coming to a country with a civil code, or well, like Louisiana also has a civil code with different traditions of how we exchange land and how we transfer land and how do we keep it? Who gets to be the owner? Some things are common, not all of them. I remember when those first months after Maria, good intentioned people that had worked on disaster recovery before kept asking us about why don't we start or we don't create an instant title program so we can do that and people get their title and they can get aid. Well, we cannot do that because our system doesn't recognize that. I still don't know what an instant title is. That's not how our system works. So when we're trying to match two different legal systems, a lot of people get stuck in between the frictions of those two.